The Honorable Court of Appeals of Tennessee is now in session. You may be seated.
Thank you, Madam Clerk. I want to welcome you to the Tennessee Court of Appeals. This afternoon, your panel consists of Judge Bryson on my right, Judge Davis on my left, and myself, Judge McClarity. Madam Clerk, are there any preliminary matters?
No, sir, Your Honor.
In that case, will you call the first case for us?
Yes, sir. In Re Shyenne G et al.
I'm sure both of you know that there's a total of 15 minutes per side to present your case. The appellant, however, is allowed to reserve some of that time for rebuttal. Okay. Sir, are you prepared?
Yes, Your Honor.
Then you may come forward. Do you want to reserve any rebuttal time?
Yes, Your Honor. I'd like to reserve 4 minutes.
4 minutes? Okay, then you may proceed.
In the words of the Supreme Court of Tennessee at Memphis, in the case Hodges v. S.C. Toof and Company, clear and convincing evidence means evidence in which there is no serious or substantial doubt about the correctness of the conclusions drawn from the evidence. In her initial petition for adoption, the appellee states that biological mother and father have not had visitations or provided support for the minor children within 4 months of the filing of the petition and have abandoned the children. The trial court found that the relevant 4-month period for this termination of parental rights to be considered is from November 8th, 2020 through March 8th, 2021. That is not in dispute. At trial, appellee directly contradicted her own pleadings by stating in her testimony that DCS the Department of Children's Services, had been conducting visits between the parents and the minor children until December of 2022, and that mother visited twice a month until that time. Additionally, appellant directly contradicted appellee's pleadings in his testimony, stating that he had visited up until February of 2021 and provided photos introduced at trial that he had taken with the children at some of the visits that took place during that time, specifically 2 in November and 2 in December of 2020. Appellant's mother, Lisa Redman, corroborated appellant's testimony that he visited with the children during the relevant 4-month period, that she had taken them to some of these visitations, that he had sent the appellee money through her meaning Ms. Redman, and that child support had been collected through the state up until December of 2020.
The mother is not a part of these proceedings, right?
I'm sorry?
The mother is not a part of these proceedings.
No, she is not a party.
Now, the court made a credibility determination regarding your client also. Is that correct?
Correct. They weighed the appellee's credibility over the appellant. And we would argue that this was an incorrect determination for several factors. The trial court even admits that, quote, father's testimony aligns with others. However, the court claims that father could not testify with specificity, but stated only generalities as it relates to visitation and support. We would argue that this is a misrepresentation of the facts, as appellant provided photographic evidence of his visitation with specific dates listed. These are the only exhibits and only actual evidence that was introduced as exhibits in the case. Appellee's testimony, we would argue, arose to nothing more than, well, no, he didn't. I think, again, it is also important to note that the trial court never made a determination on the credibility of the appellant's mother, Miss Redmond, who corroborated appellant's testimony. Now, to address some of the concerns that the trial court raised, that appellant was speaking in generalities as it related to visitation and support. It is true that father did not save receipts, and he admits that his Cash App was no longer accessible, and that he did not photograph every single visit he attended. But father is being asked to prove his contributions and list specific visitations that occurred over 4 years prior at this point. As we can note, this case began in 2021 and was heard in December of 2024. I do not believe it is unreasonable to expect that appellant's testimony may not be as accurate as it would have been had this hearing and this trial been held in a, I understand the COVID, but just a more timely manner. I don't mean to inference that there was any wrongdoing in there. Additionally, the trial court makes no attempt to reconcile or even reference the contradictions in appellee's testimony and pleadings. There is nothing stated by the trial court to reference that, again, appellee's pleadings that mother and father had absolutely no visitations during the relevant 4-month period was directly contradicted by appellee's testimony and by appellant's photographic evidence. Disregard appellant's credibility. These are photographs that were introduced into evidence. They are proof that he had visitations, at least 2 in November and at least 2 in December. This directly contradicts appellee's initial petition and pleading.
Was that during the relevant 4-month period?
Yes, there were two photographs that were presented into evidence in November of 2020, and 2 photographs, photographs of 2 visits from December of 2020 as well. And again, the relevant 4-month period was November 8th, 2020 through March 8th of 2021. The photographs showed appellant with his 2 children during these visitations. Appellant's mother corroborated at least one of these photos, the one that was taken December 31st, 2020, because she was also present at that visitation. Additionally, the support that was provided by appellant was testified to on numerous occasions. Appellant's mother even testified that she had been a go-between, that appellant had given her money to forward along to the appellee. And this was done as appellant had testified, and I think this is even corroborated by appellee's testimony, that the relationship between those two had a falling out back in February of 2021. So appellant testified that he often used his mother as a go-between, and he stated, and Ms. Redmond corroborated, that he had sent money to the appellee on through his mother on multiple occasions. I believe his mother stated that it was on 2 separate occasions. Appellant also testified that that whenever he would come to visit, he would spend money on the children. He says that he would spend money on the other children who were also staying at the home regularly, but he stated that he reserved anywhere from a couple to $300 that he would spend directly on his children, which would directly be on items such as clothing, shoes, gifts, and other things. Food as well, which he said were directly bought and provided to the children when he would make these visits.
Did he provide any proof as to direct support that he would actually give to the appellant?
The only evidence that of receipts, the closest thing to specific receipts that the appellant had, was that appellant had provided a text message. Again, he said his Cash App was no longer available, that he was not able to log back into that as the account had been deleted. But he provided text messages that were entered in as exhibits that showed that he had offered to send the appellee money, and I apologize. I do not intend to misrepresent, so I'm working the best off my memory for this specific text message. But that it was essentially an offer of sending money through Cash App, and I believe a response from the appellee was something along the lines of "thank you." But appellant testified that this was money that he sent, that this was not the only instance of support that he sent. This is simply just what he had a physical record of. Additionally, we would argue that the burden of proof is obviously on the petitioner in this case, clear and convincing. And we would argue that for the petitioner to provide no exhibits, petitioner had ample opportunity to subpoena records from the appellant, to subpoena financial records, including records that were not introduced, such as what appellant was making, what he was earning during that relevant 4-month period. The only indication that that appellant had been working during the relevant 4-month period was a comment that appellant had made during his testimony that he would try to go visit the children during his off days. There was no testimony taken about whether appellant was working, where he was working, and what he was making. So we have no reference for what his capacity to support was.
Okay, thank you, sir. You have your rebuttal time left. Yes, ma'am.
Good afternoon.
Yes.
I will briefly address Mr. Calhoun's first argument.
Ms. Clark, would you care to pull the microphone down? Thank you.
Thank you. Regarding visitations, I would like to point out that in his affirmative defense that was filed on his behalf, he stated that he had visited with the girls on January 31st, 2021 and February 3rd, 2021. At trial, he testified he had visited in November of 2020 and March of 2021. So this is what the trial court, Chancellor Armstrong, had problems with the inconsistency in their testimony. And that went to the credibility issues of Mr. Calhoun. Regarding his support, he testified, he stated in an affirmative defense regarding support that on December the 31st, 2020, he provided a cake, some ice cream, and food in an unknown amount, and he paid $20 to petitioner on April the 6th, 2021 through a Cash App. Those were his statements in his affirmative defense as it relates to support. There was no, during the trial, it was something totally different. I paid this amount, I paid that amount. I sent money through my mother to the Miss Calhoun, who is actually the maternal auntie of Mr. Calhoun. So we have a family relationship that's going on here. The petitioner and the appellee is the sister of Mr. Calhoun's mother. So there is some familiarity here with the family as it relates to his mother, the petitioner, and Mr. Calhoun. So when the trial court looked at the inconsistencies, and that went to his determination of credibility. He just didn't believe the testimony of Mr. Calhoun. In rebuttal, Miss Deborah Calhoun, who was the petitioner in the lower court and the appellee here, she testified she hadn't gotten any money from him. That he, on one occasion, may have bought some clothes or something. And in his own testimony, he stated that. I didn't give her any money, I just started buying things. But she's stating that on one occasion, he may have bought some shoes or something like that. But I think the trial court was there, listened to, in very detail to the testimony, got the transcript, and was able to really abstract what was really going on in that situation. And he ultimately proved that Mr. Calhoun had abandoned his children for failure to support them. He had abandoned them by failure to visit. He gave conflicting testimony in his affirmative defenses when he visited, and then at trial he testified to something different. And also, as a grounds for termination of parental rights, the children had been removed from the care and custody of the mother by the Department of Children's Services back in 2019. They were placed in foster care, and the mother was given certain things that she had to do. The father was given certain things that he had to do. So in 2020, those things had not been accomplished. The father approached his auntie, Ms. Deborah Calhoun, who is the appellee here, to see can she get them out of state custody. She filed a petition in juvenile court, and she was successful. They placed them in her home. And things kind of went down here from there, mainly with him. The mother is not the subject of this appeal. But there were things that father was supposed to do as far as the juvenile court case was concerned, and he never completed any of those. He was supposed to do an IOP, and his testimony at trial was he didn't do that. He was supposed to do an intensive outpatient program, and that was never completed. So that was a basis for Ms. Calhoun's petition as well to terminate. They made no efforts to get the children restored to their custody. And as of the date of trial, and based on his own admission, he did not complete what juvenile court had ordered him to do. So that gave a rise to his Ms. Calhoun's petition for termination. And the court did a very detailed analysis of the facts as it relates to the best interests of the children. He went through there, Chancellor Armstrong, and he took every single one of them that the Supreme Court has handed down that should be done, and his findings. And he found that the aggregate facts, by clear and convincing evidence, that both parties, the mother and the father, rights should be terminated based on clear and convincing evidence. And we would respectfully ask this court to uphold the decision of the lower court and allow Ms. Calhoun to give these children a permanent and stable home. There was some testimony regarding the issues, medical issues that the children had gone through. She was there with them all the way, alone. The mother nor the father ever attended any medical appointments or anything of that nature. And she's got these children on a good footing, and the court saw that they should remain there. So we're asking this court to affirm the decision of the trial court. Thank you.
Thank you. Yes, sir, your rebuttal.
Concerning the appellant's affirmative defenses, I was not Mr. Calhoun's attorney at that time. I do not know what, as far as the filings were concerned. Mr. Calhoun testified very consistently during trial. In fact, nowhere in the court's finding does the trial court say that Mr. Calhoun contradicted himself. Nowhere. Mr. Calhoun listed some of his contributions and some of his visits in his affirmative defenses. Again, I was not his attorney at that time. During trial, however, he maintained consistent testimony. He mentioned that he visited twice in November and twice in December, but he also stated that those were not his only visits. Those are just the visits he had photographs of. As far as the removal that took place in Knox County Juvenile Court, we have some testimony regarding what was in the parenting plan. However, we have no parenting plan introduced into evidence. All we have is the father's testimony, which he is working off of, which this case took place, again, at that point, over 4 years ago. Had the appellee introduced a parenting plan into evidence, which would have been very easy to do to collect the records from Knox County Juvenile Court and introduce them, the trial court would have been able to recognize and make it determined based on clear and convincing evidence, which is the standard. Instead, we have only testimony to work off of. Now, the appellant's testimony was what was taken at trial. There was a misrepresentation. Appellant testified that he had completed everything in his parenting plan. He completed a mental health assessment. He completed other things. He just had not completed his intensive outpatient treatment. And he did not have his own independent housing. We would argue that independent housing is not necessary. He stated that he spends most of his time with his girlfriend and their child and his stepson. However, his mother also testified that her door is always open to Mr. Calhoun. And Mr. Calhoun testified that his mother's living situation was just Mr. Calhoun, his mother, and his mother's husband. And it was a 4-bedroom residence. Something I'd like to add also is there were comments made by the trial court as to the quality of the visits that took place during the relevant 4-month period. The trial court did not determine that he had not visited during the relevant 4-month period. They simply determined that the visits were token. Nowhere in any of the testimony taken was there any indication that these were anything but quality visitations with these children. No one testified, they only stopped by for 30 minutes. No one testified that these were not quality visits. All we have is the evidence that these visits took place and that Mr. Calhoun can be observed in photos spending time with his children with them riding toys. Additionally, unless I am mistaken, there is nowhere in the record in the testimony that the parents never attended a doctor's appointment. Thank you.
Thank you very much. I want to thank both of the attorneys for your presentation. Your case now has been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. Thank you both. And the attorneys may be